Welcome to the NCDWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 167 of the NCDWI Guy podcast. I just got back from the North Carolina Advocates for Justice Convention, the annual convention in Charlotte. It was a blast. Got to see a lot of the attorneys from our office and hang out. We did a mock trial workshop on DMV hearings prior to the convention beginning. So it was great, like seeing everybody across the state from our team and having a time to work together. All of our attorneys, our case managers were there, and Lance Williams, who's in our Gastonia office, did an amazing presentation on DMV hearings. We then had kind of a mini meeting on communications between case managers and attorneys, trying to make sure that we are preparing for clients' upcoming court dates in a way that is the most beneficial and allows our clients the best preparation for court. So that was really productive. So a good firm meeting, and then the convention was just a blast. NCAJ does a great job putting that on, and it's so much fun hanging out with my fellow criminal defense lawyers. You never get better stories than hearing the war stories from others in the criminal defense bar. And it just got me super fired up for the Freedom Fighter Summit in October. The NCAJ convention is amazing, done really well, but it is a convention for personal injury lawyers, workers' comp, people from different legal backgrounds. And one of the things that I'm so excited about in terms of the Freedom Fighter Summit is it's a conference, branding, marketing, building your character, leadership, building your team, your culture, how to hire A players, how to have an impact in the community, how to provide a better client experience, all of these things, but specifically for criminal defense lawyers. And there's just nothing else that exists like that currently. And so I'm just super excited about that, and excited to hang out with the people that are able to make it to Asheville in the beautiful leaf season here in just a few months. I am very, very excited about that. So looking forward to that. But at the NCAJ convention, I was asked to provide the DWI update. And so today I'm going to go through the cases that I provided in that update. If you were at the convention and heard my update, this is going to actually be very different in a lot of ways than the update that I provided at the convention, because at the convention, as I said, I only went through about 3 or 4 of the cases from this past year from our North Carolina appellate courts. And today I'm going to go through the full list in terms of the NCAJ update. At the convention, I had also given some technology updates, and I'm probably going to do a separate episode on that at some point, because there's some interesting technological developments coming down the pike. But today we're going to be focusing on the case law. So I'm going to run through these cases kind of in order of topic, and kind of looking, I'm kind of going in, so to speak, chronological order of a case in terms of addressing these. So I'm going to just kind of run through these, give the case name, citation, what it's about in very brief summary, and then go dive into the case. In the episode notes, you will see links to each of the cases. So go check those out. Feel free to click on the links, because that'll take you to the North Carolina Court of Appeals opinion itself. So just diving right in. First area is checkpoints, and in that arena we've got State versus Parham. The citation is 2022 NCCOA 584, 2022 NCCOA 584. This is an unpublished decision. And effectively, this was a situation where there was not signed authorization of the checkpoint by the State Highway Patrol prior to its initiation. So the supervising officer had not given signed authority. I know that I've had several cases where that has happened, where, basically what seems to me to be the situation is that somebody on State Highway Patrol calls their supervising officer, says, "Hey, we don't have enough going on tonight." That's not what they say, but I mean, that's what it feels like in the courtroom as this is being presented, with basically zero prep work going into this checkpoint. Hey, we're going to try to do a checkpoint at this location. Supervising officer says, "Roger that, go for it." And they throw up the checkpoint. Next day, the Highway Patrol form, checkpoint authorization form, is signed by the supervising officer. So I've seen that situation come up, and that appears to be what happened in Parham. And basically the court said signed authorization of a checkpoint by a supervising officer prior to its initiation is irrelevant as long as the supervising officer gives sufficient verbal instruction on how the checkpoint is to be conducted. Takeaways from that are that you don't need a signed authorization by the supervising officer prior to the checkpoint getting started. But what I would focus on is a couple of things. So I'm going to give you some practice tips. First of all, always sequester officers, probably on most cases, but certainly in checkpoint cases. Sequester the officers. Don't allow the supervising officer and the officers on scene, whoever those are that come in to testify, know what the other is going to say in court. Make sure that you put them into different spots. And that way, here's what you can focus on is you ask each of those witnesses, what were the specific verbal instructions that you gave as the supervising officer or received as the boots on the ground prior to the checkpoint commencing? Because again, I think what a lot of times happens is that this is really the conversation. Hey, chief, we'd like to put a checkpoint up here at Jones Road, and we're going to do that from 10 o'clock to 2 o'clock. Is that okay? Roger that. Boom, off and running. And so I think focusing in on, I don't know how often supervising officers really know the nitty gritty of what they're supposed to be communicating in terms of how many vehicles are you stopping? What type of documentation are you looking for? I think they basically just say, sounds good, send me a copy of what you're doing. That's not appropriate supervision. So the question isn't paperwork, it's supervision. How much guidelines is the supervising officer giving in terms of how the checkpoint is going to be carried out? So make sure that you have cross-examinations on the specific instructions of both the supervising officer and the boots on the ground, and make sure that you sequester those witnesses. Next topic area is going to be under reasonable suspicion. So I'm going to go through, this is our biggest topic of the day in terms of number of cases. So I'm just going to kind of rapid fire the holdings from these cases without getting too deep into them. State versus Abernathy, a 2022 opinion. This case site is 2022 NCCOA 607. That is an unpublished decision. And the holding is that reasonable suspicion exists to stop a driver traveling under the speed limit in the left lane for a prolonged period, causing other vehicles on the highway to pass in the right lane. So if you have a sense of sweet justice, maybe this is the one time that you can actually kind of like raise your fist in support of the court finding in favor of the state as opposed to the defendant. If it is your personal pet peeve that there are people traveling slowly on the interstate in the left lane Well, Abernathy doing this led to a DWI charge. So again, if this is one of your pet peeves going down the roadway, it's okay as a criminal defense lawyer to celebrate this particular state opinion. Raise a fist, raise a glass, whatever you want to do on that front. Next case is State versus Barstow. This is a 2022 North Carolina Court of Appeals decision, North Carolina Court of Appeals 368. And in this case, the holding was that an officer dispatched to investigate a domestic dispute has reasonable suspicion to stop a vehicle matching the color, make, and model of the one connected to the domestic dispute, leaving the subdivision where the domestic dispute occurred. Pretty straightforward. Next case is State versus Bullock. This is a 2022 case. Case site is 2022 NCCOA 875. And the holding in Bullock is reasonable suspicion to stop exists based on an anonymous tip where the 911 caller has face-to-face interaction with the defendant, smells an odor of alcohol, was tailgated by defendant, gave the make, model, and license plate of the defendant's vehicle, and told the dispatcher which direction the vehicle was traveling. So just to give a couple of kind of tidbit facts on this front, in this case, the defendant and another driver had a kind of interaction following some alleged reckless driving of the defendant in a parking lot. The defendant, according to the caller, had gotten out, had a verbal had verbal conversation, was yelling and angry and screaming at the victim, and then victim saw some signs of impairment. Not victim, the anonymous caller, not victim is certainly the wrong term here. The anonymous caller saw the defendant drive to another parking lot, or drive out of the parking lot, and called police. The deputy that responded, the officer that responded, I think followed the vehicle, if I'm remembering the facts correctly, for about 2 minutes. So a pretty long time in terms of following. Did not see any further bad driving. Initiated the traffic stop solely based on that anonymous tip. In Bullock, it's a case that I think is helpful in terms of looking at the relevant case law. It goes through Navarrete versus California, the United States Supreme Court case on anonymous tips. It goes through Neal. It goes through Blankenship. So it really kind of looks at the Navarrete decision and the North Carolina specific decisions that have been interpreted both pre and post Navarrete. And so if you have an anonymous tip case, be prepared to distinguish Bullock from your case. Again, it's one that, even though it's unpublished, I think provides a pretty good summary of the anonymous tip case law. So this is one worth going and taking a long read at, because I think it digests the current case law in addition to providing its own decision. Next case, State versus Duncan. This is a 2023 case. Case site is 2023 NCCOA 5. And in this, the holding was that reasonable suspicion exists if an officer believes that a driver has a medically canceled license. So kind of similar to an officer believing that somebody is driving with a suspended license. If the officer believes that a driver has a medically canceled license, they are allowed to stop. Next case, State versus Dyer. This is 2022 NCCOA 880. We've got finally a defense win. Finally, one for the defense. The holding of this case is that no reasonable suspicion exists when a stop is based on the defendant's failure to use a turn signal if no other vehicle will be affected by the defendant's turn. This also is an unpublished decision. State versus Dyer, the court does what sometimes is frustrating, which is basically just says the statute on failure to use a turn signal says that this would have to impact or affect another vehicle. So the lack thereof would basically not be required unless it's going to affect somebody else's turn. In this case, the court found it would not have impacted another vehicle's ability to drive on the roadways, wasn't going to affect another vehicle. And so it basically just said, yeah, the statute is correct on this. And we're going to find that in this particular instance, no other vehicle would be affected. So make sure that you use that, because I think, providing the statute and now a case law that says, yeah, that statute's pretty straightforward is always helpful, although it seems kind of frustrating to have to do that. Next case is actually similar in terms of basically just kind of carrying out the statute. But this is going to be, to me, probably the most important case that I talk about on the episode today. And this is State versus Lewis. It's 2022 NCCOA 887. This is an unpublished case, but extremely important. So it looks at Rule 702 and who is allowed to give expert testimony. And the holding in this case, go pull the language. This is incredibly powerful. If you have a drug impaired driving case, you have an officer that is not a DRE. Doesn't matter if they've been through SFST training, doesn't matter if they've been through A-RIDE training, been through A-RIDE refresher courses. If they're not a DRE, they don't get to talk about somebody being under the influence of an impairing substance. I mean, this is a really big case. Please go look at this case. If you don't look at any of the other cases that I referenced today, please go look at this case. The holding in this is that based on the plain language of North Carolina General Statute 8C-1, which is Rule 702A12, an officer who does not hold a current certification as a drug recognition expert cannot testify that the defendant was under the influence of one or more impairing substances or the drug category of such impairing substances. The court ruled that the Superior Court judge that allowed that was an error. Ultimately, the court found in this case that the error was not prejudicial. So it ultimately did not reverse, but it found that allowing that testimony was an error. And this is humongous because I see this, so often in practice. You have a non-alcohol case with an officer, and again, regardless of whether this is their first day on the job, rookie officer, or 25 years of experience with all kinds of trainings and certifications, if they're not a DRE, they don't get to guess about the your client's impairment and what they're impaired on, and they can't opine, they can't give an opinion on your client being impaired by a drug category or being under the influence of one or more impairing substances. This is some big stuff. And Anthony Palacios, who was also at the convention, and also going to be at the Freedom Fighter Summit in October, he and I had a conversation a few weeks back where he basically said one of the things that I'm noticing across the country, and Anthony gives expert testimony all over the country. He said one of the things that I have noticed is that with the rise of current trend is that there is a rise of officers that receive A-RIDE training and a decline of officers that receive their DRE certification. And the reason for that, which makes sense to me, and it's one of the, I've definitely noticed this trend in my area, but it's interesting to hear that across the country, this is the trend. It's expensive to get officers certified as DREs. You have to go through A-RIDE, and then you've got to do a 3-day preschool, and then you've got to do a 7-day DRE program, and then you've got to do all kinds of drug evaluations under a supervisory officer before getting your. I mean, it's a big expense, time commitment to get your DRE certification. It's not easy. It's time consuming. It's expensive. And then you may have an officer that leaves 2 years later. And so is it worth having somebody who literally, a quarter of their year is devoted to training and evaluations and making sure that they're ready to go? That's expensive. A-RIDE, 2-day course, boom, off and running, ready to go. So it's a interesting thing. And it may be A-RIDE is 3 days. I can't remember if it's 2 or 3, but certainly a much lesser time frame in terms of that. But A-RIDE, the manuals and the instruction that's being provided to A-RIDE officers is that doing this course doesn't make you a DRE. What should you do if you're an A-RIDE officer that thinks that somebody's impaired by impairing substances? According to A-RIDE's training materials, you should call a DRE because you're not qualified. Like, this is literally what the A-RIDE training says. This is what Rule 702 says. And yet again, just this kind of frustrating sentiment, but one that we should be hammering on the defense end of things, is that State versus Lewis stands for the fact that Rule 702 should be interpreted exactly as it's written on paper. As soon as you have an officer that is not a DRE, that is trying to give testimony that I believe that Mr. Smith was impaired by XYZ, objection, Your Honor, he cannot say that. He is not allowed to give any type of opinion on that front. Here is Rule 702. Here is State versus Lewis. Highlight the holding in State versus Lewis because it is very black and white. The court did a great job of putting its holding into 3 very easy, meaningful sentences. Says this testimony is error. Point that out to the court and make sure that we are holding the state's feet to the fire in terms of trying to prosecute DWI cases for impaired driving that is related to substances other than alcohol, that they need to get a DRE in order to give an opinion on that front. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWI all lowercase, all one word at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. Next area is the right to silence. State versus Dunn, 2022 NCCOA 818. The holding in this case is that despite erroneous admission of statements into evidence regarding the defendant's refusal to answer questions after being advised of his Miranda rights, the error was harmless. Again, if you have some sort of Miranda issue in terms of a pointing out by the state or officer related statements, have this at the ready. State versus Dunn is an unpublished decision. The next Couple of cases are blood draw cases. First is State versus Bobbitt. This is kind of different opinion form or citation form, but this is more recent. So it's number COA 22-510. This is a 2023 decision that is also unpublished. And the holding of Bobbitt is that medical records or reports created for treatment purposes are not testimonial in nature, and as such, do not implicate the requirements of the confrontation clause. So be aware of Bobbitt if the state is trying to introduce medical records or reports. Go take a read of that. The other case is blood draw case is State versus Cannon. Number this also is more recent. So number COA 2022-572. COA 22-572. This is a 2023 case. In this situation, in this case, the facts are the defendant was involved in a head-on collision with another vehicle, killing the driver. The investigating officers found beer cans and an aerosol can of Ultra Duster in the defendant's vehicle. Officers noticed an odor of alcohol on the defendant, slurred speech, and glassy eyes. About 2 hours after the accident, defendant's blood was taken at the hospital by law enforcement. At the time of the blood draw, no warrant had been issued and no implied consent had been given under North Carolina General Statute 20-16.2. So the officer didn't attempt to get a warrant, didn't attempt to get implied consent, and so the only allowance for this coming into evidence, this blood draw coming into evidence, would be based on exigent circumstances. And in this case, the Cannon court said, yes, this is exigent circumstances. The holding is that based on the time it took to investigate an accident involving a fatality, the time to transport the defendant to the hospital, the lack of police assistance for the investigating officers, and the extra time it would have taken to prepare and submit a search warrant, exigent circumstances existed to justify a warrantless search of the defendant's blood. So, first of all, if you have any type of warrantless search, or if you have a case where the state is trying to proceed under exigent circumstances, first move should be to go look at State versus Romano, 369 NC 678 2017 case, because that court looks at exigent circumstances. That is Romano is a North Carolina Supreme Court case, so it's going to trump Cannon. It's going to trump any other court of appeals case on this issue. Romano very clearly lays out some good facts that might be similar to your case in terms of there being a number of officers on scene. Romano talks about how easy it is to get a search warrant, that this is a fill in the blank, easy form to submit, that there's in that particular county, that there was a magistrate that was routinely available to issue search warrants. So go check out Romano and try to compare your case in the same vein as Romano. Then distinguish your case from Cannon. So the biggest thing with Cannon is that it's a fatality investigation. Okay. So if your case does not involve a fatality, then that should be like a massive point of differentiation. Like, judge, the concentration of the officers on scene, and there actually really was I believe there was only a couple. I mean, it was not a massive investigation in terms of number of officers on scene, but the fact that there's a fatality investigation going on, that's what the law enforcement officers on scene judge. This is what the prosecution would be arguing. That's what the law enforcement on scene were concentrating on. This was their focus. So distinguish that fact. I mean, that's a big deal. Like that was the focus of law enforcement. They also talked about the lack of police assistance. If you have, 5, 6, 10 officers on scene, even if you do have a fatality investigation that's going on, and that is similar to your case, point out that, hey, there was a lot of officers involved here, and that was the problem in Canada. They didn't have enough officers on scene to basically get information from everybody involved, and they were focused on the fatality investigation, and the DWI investigation to some extent came second. And then finally, focus on the fact that it was a drug impairment case. So, in terms of getting a breath sample or doing something that might have been easier on that front, they knew they were going to have to get blood. How long would some of these substances remain in the blood? The officers may not have known that. So, distinguish your case from canon if you are trying to exclude blood evidence that's coming in based on exigency of circumstances. The next case that we're going to look at falls under the category of sufficiency of evidence, State versus Ruse, which is 2022 NCCOA 496. The holding there is that there was sufficient circumstantial evidence of driving presented in that case by the state to avoid a motion to dismiss. So if you have, and this was a published opinion, State versus Ruse is a published opinion. So if you have a case where you're making a motion to dismiss at the close of the state's evidence based on lack of evidence of driving, make sure that you're aware of the Ruse decision. Next, we have two sentencing cases. The first is State versus Adams. This is 2022 NCCOA 845. This is a really important decision because I think it's one that, honestly, of all the cases that I've talked about, comes up the most frequently. It's not like some groundbreaking decision, but it actually does come up a lot because in most of our cases that we represent clients on, we're going to be looking at a sentencing hearing. And so I've seen this issue come up a number of times. And what Adam says is that under North Carolina General Statute 20-179R, the North Carolina DWI sentencing statute, North Carolina General Statute 20-179R does not authorize a judge to mandate a transfer from supervised to unsupervised probation based on the passage of a certain amount of time. So if you go look at 20-179R, if you have not looked at it recently, there is a lot of important stuff in there about supervised probationary sentences. Effectively, if you have a client that would fall at a level 3, 4, or 5, if you have a client that would fall at a level 3, 4, or 5, they have had an assessment and completed treatment at the time of sentencing. A judge, in order to require probation to be supervised, has to make findings as to why that probation should be supervised. The strong default, there's mandate language in that particular sentencing subsection. The strong default or mandate is that the judge give unsupervised probation unless making findings. If they give supervised probation because they make findings that supervised probation would be justified or required, they must, again, this is shall language in the 20-179R subsection, they must allow the probation officer or give the probation officer authority to allow a transfer to unsupervised probation upon completion of either community service and or payment of court costs. So in a case, you have a client that's at a level 3, 4, 5. The judge wants to give supervised probation. They got to give findings as to why under that circumstance. And then they have to give the probation office the authority to transfer to unsupervised upon completion of community service and or the court costs. So in this particular situation, Adams, the supervised probation period was a specific time, as it is in most probationary cases. The court said, no, that's not what 20-179 allows. So I see this one come up frequently. I've had a judge or attorneys at our office have had a judge that wants to give supervised probation on a level 4, a level 3, because of certain facts that they are finding that maybe makes them want to have somebody on supervised probation, whatever it might be. And there is some pretty strict restrictions on that front that the sentencing judge must abide by. So go check out, but more than State versus Adams, go check out 20-179R, because I think it's important to remind ourselves what the judge can and cannot do when it comes to requiring supervised versus unsupervised probation on levels 3, 4, and 5 cases. Second sentencing case is State versus King. This is a more recent case, so again, citation is a little different. It's NO period number COA 22-469. COA 22-469, 2023 case. This says that under North Carolina General Statute 20-179 A22, a jury must decide whether aggravating factors exists. The court in this goes through the Supreme Court case law and some North Carolina interpretations in terms of the jury being responsible for finding that aggravating factors exist. This is one I'm going to do a little bit more kind of thinking on and reflecting on, but to me, there appears to be a grounds for an argument based on this holding that the statutory framework providing that prior convictions under 20-179C fall within the purview of the judge versus the jury is potentially problematic. One aggravating factor found in the King decision by the sentencing judge, the Superior Court sentencing judge, one aggravating factor that was found by the Superior Court judge was a prior conviction of death by motor vehicle. And so again, the court said, hey, this has got to be decided by a jury. And the King court did say that part of the reason for that is that's what 20-179 requires. So I'm not sure if it's something that you could use to push on every grossly aggravating factor and aggravating factor. But if you have a situation where the state is trying to pursue a aggravating factor, or the judge finds an aggravating factor, particularly if it's one that the state did not allege, there's all kind of great cases as of late on the notice required about aggravating and gross aggravating factors in Superior Court. So that's a whole different issue. But this just basically squarely puts aggravating factors and certainly every gross aggravator outside of prior convictions for impaired driving squarely within the realm of the jury. So make sure that the state is held to that standard. Final case is a DWLR impaired case. This is State versus Rabas. More recent case, this is number COA 22-616, 2023 case. And the facts in this case were that the defendant was charged with DWI. Immediately upon release, the defendant went back to his car and drove away. He was stopped again and charged with a second DWI and DWLR impaired. And one of the issues, so the original DWI charge was ultimately dismissed. The original DWI was ultimately dismissed on at trial on the second DWI and the related DWLR impaired. The defendant basically indicated that there was not adequate notice provided in terms of his license being revoked, that there was a lack of clarity with the magistrate judge about his license being taken. And so if you have a similar situation to that, go and look at this case, both in terms of contesting the DWLR impaired, as well as in contesting the second the gross aggravating factor of the DWLR impaired as to the second DWI. So it's very helpful to go look at this case if you have a similar situation. But in this case, the court found that the defendant possessed actual and constructive knowledge that his license was revoked, creating sufficient evidence for conviction of DWLR impaired. The defendant possessed actual and constructive knowledge that his license was revoked, creating sufficient evidence for conviction. But again, this is a very facts-specific inquiry. So there's not really so much of a holding that's based on, okay, here's a black and white. This is a deep dive into what information did the defendant have at the time of the at the time of the charge, what paperwork, was license taken, what information came from magistrate. So you can very, very likely distinguish based on the facts if you're trying to contest a DWLR impaired where you're saying my client didn't have adequate notice that he wasn't supposed to be driving or adequate information. This is a very facts intensive question. So go take a look at that. Final thought on this is, again, this is an overview. Go read the opinions. This is something that I'm doing a brief summary. Go read the opinions. Again, there's hyperlinks to all of these cases. Go to them, print them off. The next time you're sitting in court, read one of them. 2 weeks out when you have a long day in court, read a couple of them. This is one of the best uses of twiddling thumb time in district court, is to read cases related to DWI. Anytime that you're going to present a case, you want to make sure that you've really kind of digested the full opinion. So this just gives you a lead on that, so that when an issue pops up that is touched upon in one of these cases that we've talked about today, you're going to be prepared to go and grab that and make sure that you're able to go to bat for your client. So hope this 2023 update has been helpful to you all, and look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.